indicated, my name is James Ring. I've been a practicing trial lawyer in Boston for the past 30 years. This 6-minute talk is going to address some work that's being done outside of the legal field that offers us some new ways of thinking about and dealing with legal conflicts and negotiations. Numerous Nobel Prizes have been awarded in this field, and it teaches us some things that many folks find somewhat disturbing. For example, Thomas Schelling's work suggests that conflict can be understood in virtually all cases as being simply a form of coercive bargaining behavior. Now, under this view, conflicts are not generally or ultimately about what's right or wrong, or about truth or abstract justice. Conflicts, or conflict itself, is viewed as a device by which parties seek to extract desired concessions. The fact that the legal system is all about bargaining isn't subject to serious dispute. Less than 3% of cases go to trial. The vast majority settle. The reason the vast majority don't settle until the eve of trial is because that's the point at which the opportunity to bargain is about to be brought to an end. During the years leading up to that point, the parties try to coerce each other with what Schelling calls tacit bargaining. Tacit bargaining is what sovereign powers engage in when they try to extract concessions by threatening or using military force or other forms of violence. But you and I aren't allowed to try to coerce each other with violence. We gave the state a monopoly on that, and in exchange, we got ourselves a legal system which lets us try to coerce each other in an orderly, state-sanctioned way. We can, with full immunity, advance arguments and demands that extend to the very edge of frivolity and inflict enormous costs on one another, all in preparation for a trial that's virtually certain to never take place. But prior to the eve of trial, nothing that either of us says or does has any real credibility, because each of us knows that both of us have enormous incentives to lie and to posture. Early-stage settlement offers simply signify weakness and prompt further demands. Most folks even lie to themselves about what they'd ultimately be willing to settle for. This helps them put on a good poker face. When nothing that either side says or does has any real credibility, or any credibility, no meaningful bargaining can take place. It's all a bunch of cheap talk. So how do folks try to make progress in such contexts? Mediation, collaborative law, online negotiation, these don't provide a solution to the problem that I'm talking about. The case is not going to settle until self-interest compels both parties to either propose or at least not walk away from a reasonable settlement. And at that point, the case is going to settle anyway, with or without ADR. The problem is not figuring out what would constitute a reasonable settlement. You can figure that out by simply looking at the common law and the outcomes in similar cases. The problem is that figuring that out doesn't do you any good, because if and when you disclose it, it will simply become a starting point for demands for further concessions. For so long as at least one party has, or is perceived to have, an incentive to posture, the conflict is going to drag on. E-discovery, legal IT, knowledge management, armies of slave lawyers working for minimum wage. None of these visions of the legal future address the real problem, which is how to bring the bargaining to an end. The solution lies in what lawyers, a process that lawyers refer to as a Texas shootout. That's where one partner names a price at which she'd be willing to either buy out or sell out to her partner, and then challenges him or calls upon him to either buy or sell at that price. Initiating a shootout works because it's an anti-posturing device. She puts herself in a position where self-interest clearly compels her to be honest about her valuation, and thereby compels him to go through a similar process and bring the bargaining to an end. It's highly coercive but perfectly legal because it's demonstrably fair. Schelling notes the ancient precedents for such moves. Drinking wine from the same glass that you offer to an adversary to prove the absence of poison. Allowing your child to be held hostage to prove that you won't break a solemn oath. Burning bridges behind yourself to prove that you won't retreat. These moves carry within themselves evidence of their own credibility. Shifted slide there. The point is that a new set of systems now allows such moves to be made online in virtually any kind of a case. For example, with regard to Texas shootouts, there's a system that you can use online that radically improves upon the traditional procedure. This lets you propose a buy-sell price in confidence and invites the other side to do the same. the party proposing the higher number is deemed to be the buyer, but the sale price is set at the midpoint of the two numbers. So you always get a solution, and it's always more favorable to each party than what they had proposed. So if you're trying to end a joint ownership relationship on terms that you view as fair, you simply need to confidentially propose a number that you view as reasonable. If your adversary refuses to use it, they're going to have some serious explaining to do, including perhaps to their malpractice carrier. And you'll suffer no prejudice because your number remains confidential under those conditions. Similar systems are now being used to seek and secure reasonable outcomes in all kinds of cases, including all kinds of claims for money and complex negotiations, contractual negotiations over multiple issues such as labor management negotiations. These systems allow one party to unilaterally place both in a position akin to the eve of trial, where the incentives and excuses for posturing finally fall away. They let you do this at any time without your adversary's consent and without incurring any prejudice whatsoever if the matter doesn't settle by a deadline. Trafficking in cheap talk is a dirty business, and it's a dying one because the answer's now been found for this problem. If you want to lawfully induce an adversary to get reasonable at an early stage, you simply need to use one of these systems to constrain your own behavior. That's bad news for the legal business, perhaps, but it's great news for the profession and for clients and society as a whole. Thank you very much.